Did you know that not everyone present in the US can apply for a green card through adjustment of status? While immigration law does allow many people to adjust status to permanent residency, there are certain bars to adjustment that could make someone ineligible. Think of these bars as specific rules that can prevent you from qualifying if you've committed certain actions or violations in the past. Unfortunately, a lot of applicants face unexpected I-485 denials because they weren't aware of these bars. In this video, we're diving into what these bars are, how they work, and what you can do if one might apply to your case. So stick around. Hello, I'm Helene Moukarzel Bouchrouche, a business and immigration attorney helping you navigate your path to citizenship. Let's start with defining what the bars are. Simply put, for the purpose of this video, bars are immigration rules that block people from adjusting their status while in the United States. What triggers a bar? The Immigration and Nationality Act contains various statutory bars to adjustment. Some of the most common bars that result in a Form I-485 denial include the unlawful immigration status. Like, for example, a foreign national may be barred from adjustment of status if this foreign national is in an unlawful immigration status on the date of filing the Form I-485. Most likely, you are in a lawful immigration status if you have documentation that grants permission to be in the US and that documentation is current and valid. Examples of documentation include a valid visa, parole, deferred action, or visa waiver program. On the other hand, if you have been granted an immigration benefit, like the ones I just stated, but this immigration benefit has expired or has been revoked, you are not in a lawful immigration status. The failure to maintain status is a reason for denial. If you've overstayed in the US, so you stayed beyond your authorized time, you might face barriers to adjusting your status. This applies to any time you've ever been here, even on previous visits. Staying past your approved date is called overstaying a visa. Now, what's the tricky part? While your visa might be valid for a few years, it doesn't determine how long you can actually stay in the US. This is set by your Form I-94, the Arrival and Departure Record. This form states the last day you're allowed in the United States. If you stay past that date, even if your visa is still valid, you are in an unlawful stay. If you've ever stayed beyond your visa for 180 days or more and then left the US, it's crucial to speak with an immigration attorney before filing any forms with USCIS. This can create additional bars to re-entry separate from the ones related to the I-485 denials that I'm talking about in this video. Also, a bar to adjust status is triggered by unauthorized employment. Unauthorized employment means any work done in the US by someone who hasn't been approved by USCIS for employment, or has worked beyond their authorized job type or time period. For most people, working without permission creates a barrier to getting a green card. Once you apply for adjustment with Form I-485, you need to keep your employment authorized to stay compliant. Typically, applicants can file the Form I-765 to get an employment authorization document, which allows them to work legally. This form can be submitted with the I-485 or after it's filed. But remember, simply applying for a green card does not mean you can start working. And here's a key point. If USCIS denies your immigration, so your I-485 application, any work authorization based on it may end as well. Staying compliant with the EAD rules is essential if you want to avoid any new issues in your case. So, depending on how you entered the United States, or if you committed a particular act or violation of immigration law, you may be barred from adjusting status. Applicants who are barred from adjusting status should expect a Form I-485 denial unless they also qualify for an exemption. So, who is exempted from these bars? Some categories of immigrants may be exempt from certain bars to adjustment. The INA provides exceptions for these individuals. In other words, their violations of these specific rules do not result in a Form I-485 denial. The bars to adjustment discussed in this video do not apply, for example, to immediate relatives, spouse, parents, and unmarried children under age 21 of a U.S. citizen. Also, they do not apply to the Violence Against Women Act, the VAWA. Also, they do not apply to certain foreign physicians and their accompanying spouse and children. Included in these exempted categories are also certain G4 International Organization employees, the NATO 6 employees, and their family members. Again, we have special immigrant juveniles as exempted, and certain members of the U.S. Armed Forces and their spouses and children. Also, certain employment-based applicants who meet other INA exemptions are exempted from the bars to adjust status. If any of the bars I discussed apply to you and you are not exempt, you must seek the assistance of an immigration attorney before submitting any USCIS form to avoid additional issues. The fact is, there are many aspects of the green card application that can lead to delays and denials. In addition to the bars to adjustment, the I-485 denials can be the result of oversight and misinterpretations. So make sure to shield yourself by having the help of a qualified immigration attorney. If you're ready to make the US your permanent home, let Boost Immigration Law guide you through every step of the process. We're here to answer your questions, provide tailored legal advice, and make your green card journey as seamless as possible. Be sure to subscribe to our channel and hit the bell for updates on upcoming videos. Thank you so much for watching, and don't hesitate to reach out if you need further guidance. For more insights on green card applications and all things immigration, stay connected with us here on Boost Immigration Law's channel. We're excited to help you on your journey to US residency.